Now we've got with us here criminal law expert, also defense attorney Tyrone Maseko. Mr. Maseko, good morning and thank you very much for coming in. Appeals, I mean, are just that you coming up against a decision that was made already. I mean, he was convicted, he was found guilty, he was sentenced. From a defense perspective, what points would you think they will be making in his appeal?
Well, I mean, the interesting thing is whether at this stage they're dealing with the leave to appeal, which has got a different test to the appeal itself. So at a leave to appeal stage, essentially what you're asking the court to decide on is whether you should be allowed to appeal the conviction and the sentence.
So the court will be weighing whether or not there are grounds for granting such a leave to appeal.
Correct. And what we're looking at that stage is whether there are reasonable prospects of the conviction and the sentence in this case being overturned on appeal. So if the court is convinced that there are reasonable prospects, that's what they're looking for, reasonable prospects. It's not to say that they're absolutely sure that you will win the appeal. It doesn't work that way, because then it becomes fruitless to have the appeal if the determination has already been made that your conviction should be set aside.
Yeah. Now, what kind of things would a court consider in terms of granting a leave of appeal? Would they be considering looking at that judgment, looking at the conviction and the sentencing and everything, and thinking, okay, maybe there's a small chance that something might have been missed in the lower courts?
I mean, essentially what we try to do is to differentiate between questions of facts and questions of law. So it could be that the defense decides, well, we're not happy, there was evidence that was led in this matter, we're not happy with what the court accepted as evidence that can be relied on, in which case then you're dealing with questions of fact. Very difficult to overturn questions of fact, because the judge at the end of the day is the arbiter in a case. He decides whether certain evidence is acceptable or not. A trial court might not be so forgiving. In fact, they hardly ever venture into the terrain. They defer to the trial court, because the trial court sits there, look at the accused, they look at the witnesses, their demeanor, and decide whether the evidence is acceptable or not, whether it's credible or not, can be relied on or not. So it's difficult to get convictions overturned on questions of law, but sorry, on questions of facts.
Yes.
But on question of law, slightly different, because excuse me, the trial judge can err on the law. Law is very complicated. You might not admit evidence which is admissible, or you might decide you might give a wrong weighting to evidence, things like that. And sometimes we can make simple errors of law, apply the wrong law. And in that instance, it's much easier for an appeal court to decide that the judge had actually erred. So a trial court will look at what arguments you make. If they think, well, you've got a chance, it makes sense.
Yeah, any precedents in South Africa, the similar kind of cases where, I mean, we've called it in the media, triple X murder case, and then there was an attempted murder. Their sister Mali is now suffering from amnesia, but no physical evidence was really found to indicate that anyone else was in that property at that time. He tells the story. He told the court that story himself. And
that's what I find interesting about this case, is that personally I actually think that there are prospects. At the very least, there's a reasonable prospect of overturning this conviction. It's not to say that it will be overturned, but there's at least a reasonable prospect, on a simple basis that, excuse me, that the conviction was based on what do we call sorry, I lose my chain of thought for a sec.
Yeah.
But essentially inferential reasoning, the word will come to me in a sec. But it's inferential reasoning, where you take proven facts and you say, well, even though it's not direct evidence, circumstantial case is the term that I'm looking for. It's a circumstantial case where you don't have direct evidence proving one's guilt. But on a process of reasoning, you are able to arrive at a certain conclusion using inferences. Well, if you accept X, Y, Z, then you have to accept, A.
So you think the defense will be confident that they might be granted that leave to appeal today?
I think if they do a good case, I mean, if they're able to adduce or refer to evidence which they led to show that there's reasonable doubt. Remember, they don't have to prove that Breda didn't commit the crime. All they have to do is just adduce sufficient evidence that casts doubt as to whether he actually committed the murders or not. That's sufficient. And in a case where you're dealing with circumstantial evidence, there's always that possibility that you haven't proven your case beyond reasonable doubt, because that's the standard that the NPA has to hold. They've got to prove the matter beyond reasonable doubt.
I guess top of mind from you as a defense attorney, you don't recall of any person.
Well, I mean, there are a few. We've seen this play out. I mean, the Oscar Pistorius matter was interesting, but for a reverse process. But that's interesting because we had a leave to appeal in that matter. Judge Makubela is an interesting one. It got overturned. The conviction got overturned in the SCA for the very reason that the case couldn't be proved beyond reasonable doubt.
It's going to be interesting to see what the court's going to do. Thank you very much, Mr. Maseko.
Pleasure.